Good,
Great.
good afternoon and welcome to Liverpool Advocates of Windrush Q&A. We have moved it now to the first Sunday of every month, starting this month, September 2024. So we'll only be having one session per month. Thank you and welcome again. Today's topic is about Windrush updates and criminality. If you have a criminal record and you want to apply to the schemes, can you? Or if you do, what does this mean for you for both status rectification and compensation? Before we formally begin, Garrick, welcome Herman, and welcome to anyone else who will be watching this after because it's recorded for that purpose. We're not legal advisors. We are merely using the data available online. We will share the link, and I have already shared the link in the chat. If, however, from any of the information you receive here, you have any questions or queries, please feel free to contact us through our website or via email info@liverpooladvocatesofwindrush.org. We will endeavor to offer any explanation, clarification, or feel free to do some research yourself. If at any point anything I say you
Repeat
need,
that address. Just repeat that address because your audio just went down a little bit. Repeat that address, please, for the email.
info@liverpooladvocatesforwindrush.org. You can find it also on our website, www.liverpooladvocatesforwindrush.org.
Great.
If anything, again, at any point, if you need clarification or needing to check, for example, Herman or Garrick, please feel free to do so. As I said earlier, I put a link to what I'll be using in the chat today so you can follow along. Moving on to updates. There are two things that I've noticed that I would like to share. One is that the Windrush Compensation Scheme data, the Home Office has now put on the website that this will be updated monthly until further notice. And it was last published on the 25th of July 2024. So that's pretty informative and it's pretty good. Before, I had not seen any statement stating that. So that's in my opinion, a commendation to the new government, making this clearly and legibly clear when we can access the data and see which countries and how much applicants have been processed, have not, are awaiting, and information of that sort. The next piece of update that I've also noticed is from the Windrush Compensation Scheme guidance. This was published on the 9th of July 2024 for Home Office staff. And I'm looking at page 25 of a 106-page document where it lists, prior to that, the Commonwealth citizens, what the Commonwealth citizens mean, the definition, and the countries that has been affected and who can claim. At the bottom of page 25, it reads, in addition to the 65 countries, the following people are included: citizens of the UK and colonies by virtue of a connection to a country or territory on the above list, British subjects without citizenship under the law on 1st of January 1973. Although British overseas territories are not members of the Commonwealth in their own right, with the exception of sovereign base areas of Akorotiri and Dikelia, British Overseas Territories. I believe those two names that I just called are in Cyprus, or part of the Cyprus region there. These are included in the list of Commonwealth citizens in this guidance. Citizens of Rwanda, Cameroon, and Mozambique are not included in the list of Commonwealth citizens in this guidance. as these countries were never British colonies,
Mm.
but have nonetheless joined the Commonwealth. Those are the two updates that I have. Maybe it was an oversight on my part before with what I've just stated, especially about citizens from Rwanda, Cameroon, and Mozambique.
Yeah.
But I can't ever remember reading that before.
What document was that again? Could you explain that
Oh,
again? Is that a separate document that we haven't downloaded to us, or?
Yeah, no, that's a link that I have put in the chat today. So this document that I just read from is the Windrush Compensation Scheme version 17.
Version
It's
17.
yes,
Okay.
17.0. It's guidance for decision makers considering cases under the Windrush Compensation Scheme, and it was published for Home Office staff on the 9th of July 2024.
Can you just say
It's
that guidance for decision for Home Office decision workers, was it?
caseworkers.
it's
Casework.
guidance for decision makers considering cases under the Windrush Compensation Scheme. I've placed the link in the chat already. And at the bottom of the title page, it's a 106-page document. And this document was published for Home Office staff on the 9th of July 2024.
Thank you.
2024. You're welcome. And I was reading from page 25. Just going back to page 25. At the bottom of page 25, I was just reading from. And if we move on to page 26, that brings us on to criminality. But before I move on to the criminality aspect of today's session, Garrick, do you have any updates you like to share?
No, just when you get onto the criminality and deportation, I will come in with some information from the Home Office. Mm.
Okay, thank you. So, why is criminality? We all have an understanding that, in my opinion, criminality or a criminal offense is when you've done something wrong, you get in trouble with the law, and you then have a record, or it's recorded against your name that you've committed this act, offense, or crime, or whatever the case may be.
Mm.
At page 26 of the same document, the Windrush Compensation Scheme document, this page tells you about criminality. You are responsible for checking criminality, and this is the case workers in the Home Office. This is their responsibility. This is what they will be doing when they receive an application, and this is for compensation. I will briefly review status, how criminality also applies in relation to status. So it reads from page 26. In most instances, an individual's criminality will not impact on the compensation they are to be awarded. However, the Home Office has the discretion to decline or reduce an award in respect of a claimant where both of the following apply. They have been convicted of an offense in respect of which they received a sentence of imprisonment of 4 years or more. Second,
So
they're
sorry to bother you, Tanika. I'm so sorry. The
no,
document
no, no, no.
you're reading from. I'm trying to get that on my screen here and read from that as well while you're
Yes,
reading it.
yes.
Now, for some reason, is it which ones are the documents you put on the system today in the chat? Is it which one is it?
Okay, one moment. What I'll do, I'll share it again.
The criminality one I've got is just a PDF.
Yes, I'll share it again. There, I just shared it.
Yeah,
And there's a
that is the
Windrush
PDF. Yeah,
Compensation Scheme 1 PDF.
yeah.
What I'll do, I'll delete the earlier one, which will remove any confusion. So the last thing that I shared is the one I'm reading. And that is at page 26, which I've started to read.
Just pause a moment. Let me just welcome Roland has just joined us. Roland, we've just started, and Tanika is giving us some updates. And the references in the chat is the documentation that we're using for the updates. And Tanika is actually reading directly from the PDF document, which is guidance for case management, etc. So we've just started on that document, so you can follow through on that document or download it yourself.
Sorry, good afternoon. I'm just listening. Okay, thanks.
Okay.
Page 26.
Yes.
Okay, I'm trying to find what's the heading before that. I can't make it out, to tell the truth.
Page 26 is criminality. And prior to that, the previous heading is Commonwealth citizen meaning, and that's from page 24 with a list of countries. Page 26, the heading is criminality.
And that's the Windrush Compensation Scheme data, June
No,
2024.
That's the last link that I sent in the
It's
chat.
not that.
If you click on the last link that I've posted in the chat, it should take you exactly to where I am, the document, and scroll down to page 26.
Right there. I'm getting there. Here we go.
No problem. No problem.
Right, I'm there now. Thank you. I'm there.
You're
Thank you very
most
much.
welcome. You're welcome.
Thank you.
Okay, so I will continue from the two categories that apply. So one, they have been convicted of an offense in respect of which they received a sentence of imprisonment of 4 years or more. And secondly, their offending was of such a nature that it makes it inappropriate to make an award in whole or in part. These instances only In these instances, only awards for impact on life will be affected. Before I continue, I'll explain what I've just read, as we've done and we will continue to do in our future sessions. We're speaking about criminality in respect of the Windrush Compensation Scheme if you were to make an application. Here, the guidance states that any award, if you do have a criminal record, for example, we're going to use a case study to make this simpler. So claimant A has committed an offense 5 years ago, and claimant B committed an offense 20 years ago. Both claimants A and B have been here in the UK legally for 40 years. The Home Office has discretion as to whether they're going to let both claimants A and B, their criminal records, affect their compensation claim or not, whether to decline an award or not. The first thing that the Home Office will consider is if the person has been convicted of a sentence where they were imprisoned for 4 years or more. The next thing that the Home Office will consider is if the offending was of such a nature that it will make it really wrong, awkward, inappropriate to actually offer claimants A and B an award, either for what they've experienced by being unable to prove their legal status in its entirety or in
So
part.
you cut out there that part after you said sentence or imprisonment of 4 years or more.
Okay. Yes, thank you for letting me know. I was referring to the second bullet point, which is the Home Office then has discretion as to whether, based on the nature of the offense that claimants A and B would have been convicted of, whether the nature of said offending would make it awkward, inappropriate, wrong to actually offer them an award, either in whole or in part, based on their experience of being unable to prove their legal status. Because that's what the compensation scheme, the Windrush Compensation Scheme, is about. And also, with regards to criminality and the compensation scheme, it only will affect the category titled impact on life, not your housing, not education, not immigration fees that you may have incurred, either A or B, claimants A or B, from the case example that we're using, only under their impact on life. An impact on life considers all non-monetary aspects. Moving on. Sentences of imprisonment of 4 years or more for offenses such as murder, rape, or sexual assault with a minor will likely result in awards for impact on life being declined. So if claimants A or B were convicted for to imprisonment or sentenced for more than 4 years because they murdered someone, they raped someone, they were convicted for sex or sexual assault with a minor, they will not, according to this document, receive any award under the impact on life section of the Windrush Compensation Scheme claim form or claim. Where this is the case, you should consider whether there are circumstances since their release from prison which point to a reduction in the impact on life award being appropriate rather than declining it. For example, because they have dedicated their life to working with the community and the police to prevent others from committing similar crimes or charity work. You should check with the claimant whether they have any such evidence. So here they're stating that maybe we will not decline the award in its entirety for the impact on life section, but we may be able to offer you a percentage. Bearing in mind the two offenses that A and B committed, they were 5 years ago and 20 years ago. We have not yet given each offense a name. We can come up with something together. If such evidence is forthcoming, you may consider reducing the award for impact on life by 50% rather than declining it. That's by half. If no such evidence is forthcoming, you should consider declining the award for impact on life. All claims where the claimant has a sentence of 4 years or more should be referred to a team leader in the first instance. You should recommend whether, based on the nature of the claimant's offending and mitigating circumstances, since their release from prison, compensation for impact on life should be awarded in full, reduced by 50%, or declined. All claims where the claimant has a 4-year sentence will subsequently be submitted for ministerial sign-off. All claims where the claimant has a 4-year sentence will subsequently be submitted for ministerial sign-off, meaning it will go to the minister in charge. This does not apply in relation to a conviction and sentence under the law of a country outside the UK for conduct which on the date of conviction did not constitute a criminal offence under the law of any part of the UK. That's the end of criminality under the compensation scheme. So, going back to our case examples of applicant A and applicant B. Applicant A committed a crime 5 years ago, applicant B 20 years ago. Applicant A was convicted of a sexual offense, and 20 years ago, applicant B was also committed to imprisonment for rape. I would like to ask the audience if they think because claimant B 20 years ago was convicted for rape for 4 years, do you think it will affect his claim today? Equally for sexual assault with the applicant A 5 years ago, would that affect his claim? And by what percentage do you think? Yeah, Garrick, I see your hand up.
Yeah, just before I answer that point, the point I was going to ask in relation to whether or not you've dealt with any case that comes under this category of individual who have committed a crime, and whether the case was processed, whether successful or unsuccessful. But in terms of the question you asked, to come back to this point of these two case study as to the 20-year the case the incident 20 years ago, I think that will be reduced by 50%. That's just a guess, without any, it's just a guess on that.
Thank you for your answer. Going back
Can
to
I
what?
can I make a suggestion?
Yes, go ahead.
The thing is that word discretion is such a broad brush. Maybe also with regard to ministerial aspects, with a Conservative and a Labour minister, there may well be differences there. However, I suspect a rape or any serious assault, whether it's 5 years ago or 20 years ago, is serious. So it depends of the severity, and a lot of that we won't see, will we? The ministers and so forth, I suppose, whatever evidence the client has got, what they can provide, or what you would go by from what they tell you. So it could be of a toss of a coin on some, but I would say maybe if a person has shown enough contrition, if they've worked hard in the community and so forth, they may well be a greater reduction. It might be harsher for someone who's committed offence within the last 5 years with regard to their reduction. It may be a lot of won't be as good, actually, harsher in a reduction, but most probably more with regard to someone over a number of years if it happened like 20 years ago. But the word discretion is a broad brush. But I suspect there would be a decline of around about that 50%, most probably. Yeah, it depends what sort. And also, I think there are cases there it's what's known as the public mood to some offences there, as opposed to 10 years ago, 20 years ago. There's a severity in it. However, even if it happened 20 years ago, people are still holding the view, but it's serious now. So as far as we're concerned, it was serious then. Yeah. So I suppose I've posed more questions than answers. But I'm just thinking about what you're saying, because we have to be, we have to be. See, I could. All right. Here's an elephant in the room. I'm a female caseworker, and I'm totally repulsed at what's happened. Totally repulsed at what's happened. Yeah. I could also be a female minister. The tables may well turn if it's actually males involved as well. Yes? I'm just talking about human nature, how people may well view things. Yeah. And whether they have sons or daughters or what, nieces or nephews or whatever. But see, because that word discretion does give a broad brush to brush it under the carpet, so to speak. Yes? or with regard, but also you've got that allowance with regard to the reduction. So that depends. It's quite subjective, I suppose, in that sense. But it's interesting. Thanks for that, because I've got an easy session of discussion with my particular person. So I try to actually do it in a form of the decorum, as such as yourself, Tanika and Gary.
Well,
Yes, so I shouldn't forget Roland as well. Although Roland could be a bit more robust, I don't know. So I may well have to. I'm going to have to, have a discussion. And some of this is as well. This is with the compensation scheme.
yes.
I want people to relax and talk to us. But some of these are areas that they have to venture and want to talk and must trust us. And if they don't trust the scheme and all the publicity and all the rest of it's going around, it's not good. The good thing is I've got the client's quite positive, very positive,
Good.
and is adamant they want to go through with their compensation. And I think I'll have a good conversation with the gentleman, and I'll keep you abreast of that. Actually,
Okay.
I really will do. So in actual fact, I think this is a good way ahead. And even I know with Garrick has had areas and also Roland areas with regard to pensions and so forth, to zero in on some of these areas and just concentrate on them. Because I know in the community as such, the issue with regard to this has come up and there's been like loads of arguments. People there's not been a surety of what they're talking about. What you're giving here is some guidance as such, sort of plotting a way forward. Because I know there will be particular members in the community who would have been blighted for good or wrong or right reasons and so forth. Yes, with regard to criminality. I know it's a big thing in the community, so I think it could be a plus. I'll be using that as a plus, actually, of actually trying to have a way to be relaxed, to be able to know how to go about it. Yeah, so thanks, but I'll keep you abreast with
Thank you
that.
for
Thank you.
that, Herman. You're welcome. We're not finished on criminalities yet. There's more to come.
Oh,
But I
no.
will, yes, but I'm trying to take it in bite-sized chunks
Yeah.
as per the guidance so that people can clearly follow where I'm getting the information from, what I'm speaking about. And this is just my interpretation. We're all reading the same document. You can interpret it differently. But if you have any specific questions with regards to criminality outside of the Windrush scheme, please see a qualified legal practitioner who can help you through that.
Okay.
But going back to your contributions over the questions, some of them will be answered later on.
Okay. All right. I'll leave
Equally,
that
some
as
of
a
the things that Garrick said will also be addressed a bit later on.
thank you.
You're welcome. Going back to what I think maybe will happen with claimants A and B of 5 years. Unfortunately, in my experience of assisting claimants with criminal records, it doesn't matter how long it's been. For example, it could have been 40 years instead of 20 years. It will still be considered. However, I have seen a reduction applied, whereas I've seen it also declined categorically. And again, it is down to the discretion of the Home Office. It is down to ministerial sign off if that person has been convicted and sentenced or in prison for more than 4 years. So these are things people have to know. People may come to you and say, well, why? Or claimants A and B. Well, I've experienced depression. I've had serious medical conditions because I could not work, because I could not prove my legal right to be here when I did have a right to be here. Unfortunately, even though all of those may be valid and would have entitled them to an award under the Impact on Life, otherwise or but for having had or having had have a criminal record or committed a criminal offense maybe when they were a child or a teen, it's going to be declined or half significantly. So
Yeah.
these are things we do need to know. We do need to let claimants know.
Hmm.
The next
Just to
document.
jump in there, it's at precise meeting very much in the community. There are people now, late 20s, early 30s, 40s, whatever happened previously, they've left that behind 20, 25, almost 30 years ago. But funny enough, it's still even an inherent problem when they try to get jobs today. Yeah, various issues. So I'm glad that what you've mentioned there, because I know that is a real brain for many people. So thanks for saying that and being quite frank with regard to people being declined. Okay, but they're just declined on the impact of life, isn't it? It's not the housing.
Precisely.
Yes.
Yeah, because I think there's a misnomer out there. People say, "Oh God, if you've got I get nothing. Oh no, you've got this." So it's gloves where you've actually zeroed in on that particular area. So that's clear, because the misconception is, oh, criminal, oh, forget it. That's it.
And I think that's a really good point when we're having conversation with potential claimant. What you've just said, Erman, is, for people to understand, it doesn't forfeit your entire claim, just that particular aspect around impact on life. So people need to understand the difference.
Precisely.
Yes. Yeah. Thank you. Yeah. It's made it clearer for me, because until I've had this conversation here with yourself and Garrick and Roland and the like, that wasn't clear to me. It was almost like it's almost a toss of a coin, or how a caseworker or minister falls out of bed on the morning when they decide on the case, But it's quite interesting what you've said there. That's given some ideas with regard to even in delivery of some of the Windrush Compensation Scheme, especially this particular area in the community. Thank you.
You're most welcome. I've just put another link in the chat. I've deleted the previous one for ease of reference. So the next link that we'll move on to, the next part of criminality that we're looking at today, is a status rectification. Now, just for clarity purposes, you cannot get compensation unless or until you've rectified your status.
Yeah.
Now we're going to be looking at criminality under the status aspect of the Windrush the Windrush scheme. And the document, or the link to the document that I put in the chat, is the Windrush Scheme Casework Guidance. And I'm on page 33 of a 52-page document.
Have you just put that in?
Yes. I had it before. I deleted it and reposted it, so it's the last link. You know exactly which one to go to.
Okay, and you've just posted that. I've got 5 postings. You've put 4 postings in today.
1545. You look at this 1545, you'll see that.
Yes.
Great, it's just come through. Got it. Okay. And what page are you on?
33.
Thank you.
You're welcome. And it's titled, it's part of the page that reads General Grounds for Refusal.
Right, I'm there. Thank you.
You're welcome. So in this status rectification scheme, this is the only part that would lead you to the consideration of someone who has a criminal record, if they're going to be applicable to apply to the scheme or not, or what the other consequences are, because a person may hold a criminal record, irrespective of however they attained said criminal record. On page 33, general grounds for refusal. When considering whether the general grounds for refusal apply, you should refer to the following guidance, and it has a link that takes you to a different page. The link reads General Grounds for Refusal, gov.uk, General Grounds for Refusal, internal. The hyperlink is for the gov.uk. Where a person is the subject of a deportation order made on criminal or non-conducive grounds, they should be advised to apply to criminal caseworker in immigration enforcement for their deportation order to be revoked. Applicants should be directed to apply to the criminal caseworker at the following email address. I've clicked on the hyperlink above, which reads General Grounds for Refusal. And for the benefit of the audience, I will post that link in the chat now for ease of access. So I've just posted a link in the chat and I'm on page 11 of 34. That document is a 34-page document. It was published for the Home Office staff on the 16th of January 2024. However, page 9 of said document reads criminality rules for applications made before 9 a.m. on 1st of December 2020. I'll read that again. Criminality rules for applications made before 9 a.m. on the 1st of December 2020.
What page, please?
Page 11 of page 34.
Thank you, I'm there.
Okay, brilliant. And why page 11? Because as you may remember just now, we were just speaking about, even in the compensation scheme, about sentences of 4 years or more. I thought it important not only to draw the relations with the compensation scheme, but this is status related. What does 4 years or more actually mean? And here it goes a bit deeper in explaining. Where the person has been convicted of an offense and sentenced to a period of imprisonment of at least 4 years, you must refuse their application. So if someone who was not trying to apply under the Windrush scheme, but just an ordinary immigration application, my interpretation is that this is a document also that they'll be using. So for Windrush purposes, this is what they say applies. This is what the caseworkers will be considering when they're looking at a Windrush status application or compensation scheme with someone with a criminal record. You must take into account a sentence in this category on an indefinite basis for all applications. However, you must always consider if there are any other very compelling factors which amount to an exceptional reason why the application should be granted. A person who has received a custodial sentence of exactly 4 years is included in the at least 4 years category. Any sentence imposed by the court in months rather than years, that is equivalent to 4 years or 48 months or more, should also be considered in this category. Refusal will be appropriate regardless of how long after the sentence in question ended. Before I thought I read it was discretionary. Here, refusal will be
that word, didn't it? It used the word discretionary. It did
yes, maybe
previously,
it's
but
my
this one, the language has changed, hasn't it?
and I feel so, unfortunately, but maybe it's just my interpretation.
Mm.
I continue. Sentences of between 12 months and 4 years. Where a person has been convicted of an offense and sentenced to a period of imprisonment of at least 12 months, but less than 4 years, you must refuse their application unless 10 years have passed since the end of their sentence. If they're applying for settlement, you must refuse a person with a sentence in this category unless 15 years have passed since the end of the sentence. You can make a mandatory refusal under paragraph and it gives you the paragraph details there. However, in respect of entry clearance and leave to enter applications, you must always consider whether there are any very compelling factors that amount to an exceptional reason why the application should be granted, even though fewer than the required number of years have passed since the end of their sentence. I'll pause there. So, combining the sentence of 4 years or more and what I've read so far, which is halfway of the current heading sentences between 12 months and 4 years, I have not clicked on exceptional reasons. But this is where I'll advise anyone who does not fall under the Windrush schemes, if they need immigration support, contact an immigration specialist. Because what we've read today, along with the other provisions and hyperlinks, will need to be read in conjunction. So contact an immigration specialist. For the purposes of the Windrush schemes, here the information which will be considered for status rectification is that you will get an automatic refusal. However, in my experience of dealing with Windrush claims, people who've had the prescribed minimum, i.e., over 12 months, less than 4 years, some people have been deported or subject to deportation orders. Some people have already been deported and are now trying to come back, and they have not met the prescribed 10-year period based on what they were convicted for to come back. In some instances,
That's why they've been refused. Yeah. Okay.
precisely. But even if somebody is eligible under the Windrush scheme who happens to be overseas because they have been deported, they still have to, one, apply for the deportation order to be lifted first, as it said earlier when we read it, before they can try to apply as a returning resident under the Windrush schemes. How viable that is, how successful would they be through that route? I am not sure. I have not completed in its entirety that process of one, assisting someone through a legal representative to get the deportation order lifted, and then assisting them under the Windrush scheme, whichever applicable in this case, returning residence status, to come back to join their family and loved ones. So
It's quite interesting what you're saying there. So that's quite a serious one, in the sense where initially now, when anyone talks about that and they've had to be deported back, there's a bit more to the admin, let's say, so to speak. Yeah.
yes,
That the deportation has to be lifted first. Whether that's going to be lifted first, get a decision on that before proceeding. Yeah. So that's like on Monopoly board, advance to go, don't collect £200 when you begin. So how that one's going to be, it's quite interesting. I know we haven't got to exceptional circumstances yet, cases, but I was thinking, I've been sentenced to 4 years. However, I've only served 2 years. Could be a combination of good behaviour, so forth. There's real issues on prison places as now, as you know, in this country as well. So some people before falling shy of some years or whatever. But listening to what you're saying there, even at 12 months, yes, there are issues I could actually see. So I'd be interested to see what would be the issues with the exceptional circumstances where people would come through. Are you aware of any in your experience at all, Tanika?
exceptional reasons, no. However,
Okay.
I don't know of anyone who has been deported for having a 12-month imprisonment. I don't know if that is the rules under the deportation rules, so I don't know for sure. But it will be interesting to read and to research to find out exactly under what situation someone can be deported.
Yeah.
But for the purposes of this today, so I wanted to correct myself by saying that there.
Mhm.
For the purposes today, if you've been in prison for at least 12 months, 4 years or more, then here on a ordinary immigration application, because this applies to both Windrush status and normal applications, it says that the caseworker must refuse the application.
So they're forcing you to find an exceptional circumstance there. It's a bit like what Garrick cited earlier. I mean, there appears to be an ambiguity later on where the language is changed, doesn't it? So, but you have to be very careful how you move ahead there. But thank you for that distinguishing with regard to Windrush and actually non-Windrush with regard to status claims as well. It's quite interesting. Okay, thank you.
You're welcome.
I've got to do some mugging up on the deportation stuff. I've got to do some reading on that. Okay.
Continuing from the middle of sentences between 12 months and 4 years. A person who has received a custodial sentence of exactly 12 months or 1 year is included within the at least 12 months but less than 4 years category. Similarly, a sentence of 52 weeks should be taken to be equivalent to 12 months, and so must also be considered in the between 12 months and 4 years category. You must take the end of sentence to mean the entire sentence imposed, not just the time the person, not just the time the applicant spent in prison, which is what you were just referring to, Herman. For instance,
Okay.
an applicant who is sentenced to 2 years imprisonment on the 1st of January 2013 should not be granted entry clearance or permission to enter until 1st of January 2025. 10 years added to the end of the 2 year sentence imposed. So going back to your question just now, Herman, even if the person only spent a few months, looking at this last paragraph that we just read, from the end of that person's custodial sentence that was imposed, the 10-year prescribed rule or 10 years would have been added. So what does that mean for people applying under the schemes?
Yeah, they've got to see how far they are down the road, haven't they? In that 10-year spell, basically. Yeah.
Is it though, because they're already here and they would, is that, forgive me, I'm rambling. That's a lot to digest. So hence I'm rambling. It's a lot to digest.
Can I just come in there, Danica?
Yes, sorry, Gareth. I wasn't looking
Yeah.
at the screen.
Just some additional information that I found looking at the immigration rule part 13 on deportation, taken
Yes.
the date the 6th of June 2024, but it was published as far back as 25th of February 2016. It's a lengthy, but there's a couple of really important point to note.
Before you go into deportation, Gareth, because that's something that I didn't want us to cover today.
Okay.
There's only one last section, sort of paragraph left, main paragraph on criminality that I like us to cover today, and
Okay.
then we can speak on that because
Yeah.
we should have more than enough time.
Yeah.
Thank you for that, though. So the last paragraph with regards to criminality is sentences of less than 12 months. The reason why we're focusing also on criminality, just for reflecting purposes, is that if someone does have a criminal record and they want to apply to the schemes, these are things that we'll have to consider or have to be considered by the advocates like myself to see how best we can help that person apply and what the considerations that the case workers who will be assessing their applications will be taken into consideration. So the last section, where a person has been convicted of an offense and sentenced to a period of imprisonment of less than 12 months, you must refuse the application unless 5 years have passed since the end of their sentence. If they're applying for settlement, which that's the point of the status Windrush status scheme, they're rectifying their status, you must refuse a person with a sentence in this category unless 7 years have passed since the end of the sentence. However, for entry clearance and leave to enter applications, you must always consider whether there are any very compelling factors that amount to an exceptional reason why the application should be granted, even though fewer than the required number of years have passed since the end of their sentence. And lastly, you must consider a person who has received a custodial sentence of exactly 12 months in the between 12 months and 4 years category. So I think if I was to look at this properly on page 11, that part may more apply to Windrush claimants. And on starting at page 12 is for entry clearance and leave to enter applicants, which will be returning residents, that part. Any questions?
Yeah.
I'll put it for, I'm just digesting all of this information. Go ahead, Herman.
I'm just thinking, okay, they said, although maybe I'm trying to be too clever here, but okay, I could fail on the impact on life, yes, and all the other areas with regard to Windrush, yes, with regard to an application. Yeah. But can I come back in several years if the scheme's open and actually put in an application for the impact on life? I know I'm just throwing that out there. I suppose these are questions we have to pose to the Home Office and so forth. I would have thought at the moment how this country's going with money, they're saying no. But I'm just sort of thinking, I'm just thinking I'm just thinking of some ways. I think one thing what you've said, you've made clear, is actually have a template of the various pathways, as it were, of what you've explained here between the 12 months to 4 years and discretion and so on and so forth. You need to have that initial stage when someone actually, and if they could disclose that as ASAP with you to go through things. So that's, I'm thinking of strategize how you to save time or work efficiently, and also with a sensitivity as well initially, so you don't build up hopes too high in particular areas of the categories of claim, because that would be a particular area if someone actually has particular aspect of the criminality. We know there's an issue with regard to the impact on life. We know that. Okay. Thank you. I'm just thinking, what do you think what I've just said there?
Well, there are
sorry?
two things that stood out to me what you said there. I think you were conflating the status rectification scheme and the compensation scheme. What we've just looked at in
okay.
what we've looked at in its entirety, i.e., the sentences of 4 years or more, and the breaking down of sentences between 12 years and 4 years, 12 months, sorry, and 4 years and under 12 months, that is a status rectification. That's for status. And before
which
you
is
can
the first step before compensate. That is the first step to fulfill.
Before you can go, yes.
Yeah,
So you have to know or identify, okay, you're eligible to the Windrush schemes. Check. However, going back to our case scenarios A and B, applicant A committed a crime 5 years ago, and applicant B 20 years ago. So they both have criminal records. How does this information now for status? First, they need to rectify the status before they find out whether they're eligible for compensation.
Yeah.
How does that apply? So one, again, 5 years ago. Okay, let's apply it to the information we have. We didn't say how long he spent in prison for either of them, or if it was a custodial sentence. So assuming that the claimant A spent 12 months in prison 5 years ago, and claimant B was less than 12 months 20 years ago. So for
Yeah.
claimant A, that's between 12 months and 4 years. It says that the caseworker must refuse their application unless 10 years have passed since the end of their sentence. 10 years has not
Yeah.
passed since the end of his sentence. It was only 5 years ago.
Yeah.
And this is on page 11 I'm referring to,
He's
reading from.
got to wait another 5 years before he would be able to actually make the
That's my
application.
interpretation from
That's how
looking at
I
this,
would understand that. Yeah.
but
Yeah.
I
But
don't
what,
know.
but what I'm saying, can I come again then in 5 years?
Well, this is for the status. So if the scheme is still open in 5 years' time, then possibly. But then it's still, is it not down to the discretion of the
You're
Home
right.
Secretary, the Minister?
That's
And
true. Yeah.
also, one of the things that the Home Office will look at, which is what we spoke about earlier, but from the compensation side, is the seriousness of the convictions or the
Yeah.
criminal offenses. And
Yeah.
if it would be, well, if they're liable for grounds for deportation, which that's a different topic altogether, and if it poses a threat to public safety, because that's one of the grounds for deportation. Again, that's another session.
Okay.
But that's my interpretation. So I do not believe that this information is clearly uh, clearly advertised to potential claimants to the schemes. Just one of the many things that aren't, in my opinion, as a
Yeah.
caseworker or as somebody
Yeah.
who's been doing this for a while,
Yeah.
compared to the guy, claimant B, who committed an offense 20 years ago and served less than 12 months in prison. So less than 12 months in prison, it says at the bottom of page 11, you must refuse the application unless 5 years has passed since the end of their sentence, and that has been the case. However, this person is applying for settled status. If they are applying for settlement, you must refuse a person with a sentence in this category unless 7 years have passed since the end of their sentence. So 7 years has passed. Do we still believe that is going to be down to the discretion of the minister? I think so. But
Yeah.
also, as we saw under the compensation side of things, what have they done since they've been released or since they've committed this crime? Have they turned their lives around? Like a lot of people or older people now in the youth, they may have made silly mistakes. I've had a client who committed a crime, or sorry, who was convicted of a crime, and unfortunately, it did affect the impact on life section of the claim. But it was more than 20 years ago. That's as much as I'll say. And it significantly affected the impact on life section of the claim.
Yeah.
I'm just wondering. I'm wondering if there are refusal, where the information, the refusal letter from the Home Office doesn't actually tell the applicant, in terms of criminality, tell the applicant why his application is not successful, or will it include information based on what we've just said as to the reason why we refuse your application because, your date, sentence is XY. Does any letter actually could state that? I mean, because we haven't got any case study to say whether the refusal letter from the Home Office will contain such information.
I'm trying to remember what the letter that I read stated. However, what we did put forward was the mitigating circumstances or grounds, i.e., that they've changed, and
Mm,
having testimonies from people to support that this person's character has been positive
yeah.
and conducive for the public good. They change their ways of learn their lesson. However, I do not remember what the refusal letter at the beginning has said because we did end up getting a better offer after
Mm,
we interjected or I interjected within the claim. Having said that, I honestly don't remember, Garrick. But the
yeah.
point is that based on what we've just read here for status, not compensation, these are the considerations the caseworker will be making or will have to make based on what's written when assessing an application with somebody who's had a criminal conviction.
Yeah.
The question for me then that I have for you guys is if the person does not meet the threshold of time lapsed since
Yeah.
the end of that sentence, does that then make them eligible for deportation?
Mm,
Because they're not eligible based on these rules here to get their settlement, even though they may have been here 50 years. What then happens?
good question.
There definitely appears to be an ambiguity. I think with some of this is, but initially, if we stick to the status, what you're saying, I go with that. There's one client I know. I think something he had. I think it was the early 70s, and he got. But I'm not too sure what the uplift he got on impact on life. So it's interesting what Garrick had mentioned, what the letter would state. And I know this latest client who's at the tier 1 stage, I don't know what actually happened, how he tried to negotiate the impact on life. So I have to look at that. But what letters he's had, because I've got to meet up him. So if there's anything I've got like that, I could share privy with yourselves with some, obviously
Yeah,
with some automation, with some stuff blotted out. I'll definitely do that because this is a very interesting what you're saying there. Because in a sense, how you're going to plot your application, so to speak, with your client, yeah, initially.
exactly.
So that's very interesting what you're saying. Otherwise, it's a trap door, isn't it? Yes.
Well,
So
yeah,
Unfortunately,
yeah,
this is the point that Tanika just mentioned, isn't it? This
yeah.
is this is quite an important point, and there's a fear factor around this because if the person do not meet the threshold and then red flag that this person could be eligible for deportation by the Home Office.
again, we'll maybe the next session we should look at deportation and
Yeah, because
what
you
to
what else you know it's down. What will the Home Office actually do? Because they're
What
actually using, they're saying you do not meet the threshold for status, right? In which case, if you don't meet that, does that now make you illegal to be here? Does that sort of wipe, you've got no status at all, so you shouldn't be here?
Oh, okay. So just because instead of us having to go when we have 40 minutes left, I've decided it may be beneficial if we quickly look at the deportation. So on the first form, the link, which is 106 pages long, that's Windrush Compensation Scheme Guide. They have the section detention, removal, and deportation. That's from page 47.
Mm.
And
was that?
if
Was that the first link you sent? Yes, you said.
Yes, that's a compensation. I'm just checking to see the caseworker guidance, what it states about deportation. And then hopefully, instead of us guessing, we
Yeah.
could actually, deportation is on page 17 of the status. So this time we'll start the right way around. Status, then compensation. So the same document that we were just using, Herman, on page 17 of 52.
I'm coming up to it now. Page
17.
17. Yeah,
Yeah, we were just on page 11. Page
yeah,
17 deals with deportation.
got it. Yeah,
Deportation.
yeah.
Serious criminality will be considered in accordance with existing good character and criminality guidance. Section 7 of the Immigration Act 1971 provides an exemption from deportation. And it goes on. I'm just going to skim read to see what I can pick out that may be particularly helpful. So it reads, assessing ordinary, first paragraph, assessing ordinary residents internal, this is internal use, in the UK when the Act came into force, provided that they were also ordinarily resident in the UK for at least 5 years before the decision to make a deportation order is made. Those who can establish that they meet the exemption will not be liable to deportation and so will not be deported. So that point that I just read reads, providing somebody or a potential deportee or somebody identify as potentially viable for deportation, if they can prove that they were ordinarily resident in the UK for at least 5 years before the decision to make a deportation order is made, then they'll be exempt. That's what I just read at the very
Yeah,
beginning.
yeah, I understand it as that. Yeah.
Okay, thank you. Those who can establish that they meet this exemption will not be liable to deportation and so will not be deported. So that answers part of our question.
Mm.
As set out in Section 3, subsection 8 of the Immigration Act 1971, the responsibility is on the applicant to assert that they are not in, sorry, the responsibility is on the applicant to assert that they are entitled to rely on the exemption in Section 7 and to prove that to be the case. Anyone with a right of abode is not liable to deportation. In such cases, they will normally not succeed in obtaining citizenship because of the good character requirement. So, right of abode is something that we'll also come on to. Right of abode is British citizens have right of abode. So, if you were born a British citizen, then you have automatic right of abode. Like most Commonwealth citizens had prior to, sorry, more CUKC citizens had prior to becoming a Commonwealth nation and prior to their countries gaining independence. They had automatic right of abode.
Yeah.
And then you had to go through the process of applying for settlement. And here it says, so going back to our case scenario A and B, so claimant A, who committed a crime 5 years ago but has lived here for the last 40 years, if he was to try to rectify his status through the Windrush schemes, he will have to wait for the prescribed time limits to pass.
Mm.
However, based on this, because he's been here ordinarily resident for the last 5 years, my interpretation is that he would not be liable for deportation, but he would not be eligible for citizenship either because he would not pass, as in she, um, would not pass the good character part of the natural or the citizenship application, naturalization application.
Doesn't that raise the question then, if he's not eligible to, for citizenship, um what will they do with that individual, and what's
Probably just have
his
settled
status?
status. Probably just have settled status. I don't know. That would be something only the Home Office representatives can answer.
Mm.
I am not sure, but maybe they'll just allow them to have settled status, like indefinite leave to remain, but you can't naturalize.
Mm.
However, just before you asked Garrick, I wondered, for people who are born here, but born to, uh, for example, maybe European or Commonwealth parents who may or may not have had settled status or right of abode, as we've seen has been the case with people born here 2, 3 generations, but because their grandparents and great grandparents didn't have certain status, they're still not British. What happens to them? It's a rhetorical question because I know they're already given the status of those
Mm-hmm.
to their grandparents, and they can get deported to countries they've never been to, even though they were born here and lived here all
Yeah.
their lives.
Yeah.
They do, to use what Garrick was saying, I do see that note at the bottom. Comments have been made Parliament that no information brought forward by an applicant to the Windrush help team would be passed to immigration enforcement. You must not refer a case to criminal casework if an applicant has serious criminality. That's what they say. Whether they stick to that is another thing. But that's the insurance policy we've seen. Okay, because it does leave them out on the limb, doesn't it?
Well, it does, yeah.
For what you were saying, Gary, what actually happens to them. And I was listening to what Tanika had said, whether it's indefinite leave to remain or settled status. It's quite interesting. Okay, all right, okay. It's good. I'm enjoying this because these are the little tedious things you've got to get around. You know, maybe I could get a life, but what I'm saying, these are the things we're going to need to get around. I was thinking in the bigger picture, especially the work, the excellent work yourself, Tanika, Garrick and Roland. Would it be above your station to actually at some time in the near future when you can set up a meeting with the engagement team, the Windrush team, to ask these questions specifically? Have a meet. Yeah. It doesn't always have to be Winnow, because I know with a lot of stuff, no disrespect, and with Winnow sometimes it's a bit difficult for things to permeate down, so to speak. Yes, but because because no one else is mostly teasing these things out. I don't know. I suppose Jacqueline McKenzie may well do. What I'm saying, I'm not hearing it being shared, but in a sense, with regard to your stamp on proceedings, I think that would be venture to be a good way forward. That's my personal point of view, because I would like those specific questions asked.
Policy, these
because
are
I'm sweating. Because I'm
issues.
sweating on that last comment by the Home Office there saying they won't. The caseworker is not supposed to let anyone know with regard to serious criminality. But we know at the end of the day, we're human, aren't we? And mistakes do happen. Yeah. Okay.
All right. They also state that information will not be shared, and we know that is not the case in other departments. Information has been shared across the government departments, etc. So, this whole thing is, are we got confidence in what they're saying, and will they actually stick to what was being said? Where there's no policy, practice become the policy. So again, the caseworkers, in the absence of any direct policy, they will follow something, and that become the way that they administer these things. What we don't
I could see. Yeah, sorry, I'm listening.
What we don't have is enough evidence of people who have come through the system, possibly with some sort of criminality, and come out at the other side in terms of outcomes, and able to compare, those different cases. That's something we haven't got.
Yeah, we must need to collect the evidence, but I'm sure, like yourselves, Roland, Tanika, yourself, Garrick, you're eloquent enough, because I think how Tanika's gone through, initiated with regard to that, that's what needs to be explained to them. Because they may well be able to see the errors or the ways with regard to chinks in their armor, so to speak. Yes, we could look at that. because I think this is a good way of going through it, not just saying, what about this, what about that? Go through a process. Bit of that, what you say with the evidence, obviously, Tanika's brought up, and the distinguish between with regard to the normal immigration status, but those actually coming through the Windrush route as well. And what I would like to know is some of the exceptional circumstances of reasons. I know we didn't click on those areas there, because then again, we may well view them as exceptional, but as we said, that big broad brush is still there. Yes. Discretion. Yes.
Well,
So,
I would like to take you on that note, Herman, to the compensation scheme, the deportation and removal section under this the guidance
yeah.
for deportation, which dealt with discretion, because discretion was the only time that the word discretion was used was in a compensation scheme. And what it says guidance about deportation and removal. There's also detention, but we're going to focus on deportation because that's what the criminality aspect here links to. And that's on page 50 of the 106-page document.
Okay, was that the very first? That's on
Yes.
page, so check page 50 of the 106-page document. Yeah.
Correct. Yes.
And that's for deportation.
Yes, deportation and removal is the heading. Prior to that, you have detention, removal, and deportation, which is on page 47.
Okay.
But we're going to start at page 50 because we're not going to look at detention, which is what will come before the deportation. I just wanted to briefly touch on, following on from our discussion of deportation. More specifically, these are the checks that must be conducted by the caseworker. And it reads...
Is that on the page? Is that the document 106 document? Yes?
Yes, that's the one.
Okay. Let me get there quickly then. Okay, go on. Carry on. Explain.
Okay,
Carry on.
so
I'm listening.
deportation and removal. You must conduct the following checks. Bullet point 1. Whether the claimant was deported and removed under the relevant legislation. That the main reason for the deportation or removal was the claimant's inability to demonstrate their lawful status, and that otherwise the claimant would not have been deported or removed. Noting where a claimant was deported as a result of their criminal behavior, automatic, court recommended, conducive deportation. They will generally be only eligible for compensation if they were also exempt from deportation at the time under Section 7 of the Immigration Act 1971, or because they were a British citizen, or had the right of abode under Section 21B of the Immigration Act 1971, but were unable to prove this. Where a claimant was deported as an immigration offender prior to 2000 because they could not prove their lawful status, they will generally be eligible for compensation regardless of whether they were exempt from deportation at the time. Whether the claimant's non-compliance, such as failure to report, failure to reply to correspondence, or refusing to provide readily available documentary evidence contributed towards their deportation or removal. You should find this information on CID. The part that caught my attention when I was scanning is on the bottom of page 50. You must also be satisfied of the following. That no willful default, such as giving false information or willful lack of cooperation on the part of the claimant, substantially contributed to the decision to deport or remove the claimant. Where was it? My apologies. If you go over to page 51, and there's the deportation table, the tariff table, deportation.
Yeah.
if I can take you guys there, what came to mind as I read it, and it's underneath inability to return to the UK, something that we just read. So if somebody was deported from the UK because they couldn't approve their status and they're now stuck overseas, we'll come back to the table in a minute because it's very important, but there is no claim under this scheme for any losses incurred as a result of a claimant's inability to return to the UK. Impacts experienced because of this inability may attract an award under other parts of the scheme, such as impact on life. The deportation table shows us that if someone was deported, then an award of £10,000. They're they may be eligible to an award of £10,000, I would like to say.
Yeah.
Just above it, it says amount of compensation which is payable to the primary claimant will depend on whether they were deported or removed, and if the latter, if they were removed, then the type of removal set out in the table below. So deportation, £10,000. Administrative removal with reporting requirements, £7,500. Administrative removal with detention, £6,000, and so on. So for those individuals who find themselves as returning residents after being deported because they could not prove their immigration status, here is saying they may be eligible to claim.
Yeah.
But I was under the impression that they were unable to claim now as returning residents, which
Well,
is one of the updates.
I think that's been the understanding for many people that they weren't, eligible to claim, and that has come up many times in conversation with individual. But if it's written there that in black and white, it say you may. I think the word may is the relevant word, isn't it? It doesn't say you're entitled. You may be entitled. So there's something else to be added.
Yes.
And these are the areas that we may want to get clarification from Home Office policy on, on that particular paragraph and sentence.
Can I just ask, just for some clarification, if someone could help me here, what does
Yes.
administrative removal with reporting requirements, just the administrative headings in the tables there? Because someone just help me out, please.
Yes, not a problem. So if, for example, based on my interpretation, but I'm going to use the same document to guide you through what administrative means. I don't want to give my interpretation. One moment. Um, all right, I'm going to draw an analogy. Administrative review. Like when you go for tier 1 or tier 2, you're a sister claimant with tier 1, tier 2.
Yeah,
And
yeah, I've got you. Yeah.
yeah, administrative. Or in this case, for removal purposes, the Home Office considered it necessary because it's not conducive to the public good. If you have a serial rapist, for example, that they think it will be better to deport the person, so they're administratively removing that person. Not that they um may have just maybe they just finished a crime. I'm not sure, and I don't want to give my mouth liberty. So unfortunately, I have to Google the meaning or see if I find the meaning within this document to give
Okay.
you that.
Well,
Does that make sense?
I'll try to research. I'll try to research that up, so because I need to not be lazy to go and do that.
But
Yeah.
how I'm thinking about it, however, is administrative review, such as a JR. That's an administrative review of a decision.
Mm.
But they're administratively removing with reporting requirements. So they want to deport you because They don't think that you're a harm to public or could be a harm to public, but we need to report to the detention center every week, every 2 weeks. This,
Got you.
or as you saw, the third point in the table, removal with detention. So they keep you in detention and they just fill out the paperwork and remove you.
Yeah. Roland's got a point to bring in, Tanika.
Sure.
Okay, thank
Roland?
Go ahead, Herman.
No, I'm okay. I'm ready. I'm here.
Okay.
I'm
Roland?
okay. Thanks for that. Appreciate it.
There's a couple of questions, please. Firstly, good afternoon, everyone.
Afternoon.
You just mentioned compensation, a couple sentences back, that in some cases they can get compensation. Yeah, I think you said if you were deported, but I didn't hear it clearly because the signal dropped. So what situation you were talking about that is possible if you had that impact, then are in that situation, then you could be compensated?
So on page 51 of the 106-page document, the
Yeah.
last little paragraph just above the table, deportation and removal, tariff table, it
Yeah.
reads, the amount of compensation which is payable to the primary claimant will depend on whether they were deported or removed. And if the latter being removed, then the type of removal set out in the deportation and removal tariff table. So it'll be based on that. So if they were deported, £10,000. Administrative removal with reporting requirements, £7,500. Administrative removal with detention, £6,000.
It's reduced all the time.
Administrative removal without detention or reporting requirements, £5,000. And any other removal or return where the reason for the removal or return related to difficulties associated with an inability to establish lawful status, £1,000 award.
Okay, I get it. Okay. Second question is, for descendant, you got a situation where you got a Windrush generation, and let's say, the name that was used by the Windrush generation was not correct. And then the descendant, i.e. the one that was born in the UK, gained status from the parent, but there was some inaccuracy with the name, whether deliberately so or by inadvertently happened. Can the descendant, the child of the Windrush generation, can their status be impacted due to the fact that the Windrush generation being the parent, there was an inaccuracy with the parent's name?
Well, I would like to answer that question with a question, which I know is not a done thing.
Yeah.
Even if the name wasn't an issue, we've seen that descendants are affected just because of their parents' status or nationality, rather.
Right. So the parent status, there are some issues with the parent status, then that could impact the descendant.
Yeah, just look, for example, Sakina Kid in Preston.
Yeah.
She was born here. Her child was born here. The grandmother was from a Caribbean country, and the grandchild's status was affected.
Was the grandchild affected? Oh,
The grandchild was affected when the story broke in the news.
yeah.
Sorry?
I said, I understand. I get you.
And that's not that had nothing to do with name, for example. The name and everything was clear. The lineage was clearly defined, but yet the child's status was called into question.
Okay, I understand. I get it. Okay. Thanks. I'll leave it there. Back to you, Chair.
Thanks. I think that brings us to the end of our session with criminality. In conclusion, there's a lot to consider when assessing an application or supporting a claimant who may have a criminal record or have a criminal conviction. It does not, for status aspect, It could affect whether you get your status through the Windrush scheme, but that is where you need to speak to your advocate or anyone assisting you. It will be confidential. Yeah, you do have to declare it. Therefore, you declare it to the Home Office, but they're the ones who will be assessing application.
And I think the other important thing, Tanika, to mention when you said about declaring, I think it's good if people can declare it right at the outset than later on down the road. And that's a judgment that people will have to make. I know sometimes people withhold information when they come forward to inquire about their own or their family situation. They don't give you the full facts. But like this conversation now, if people are aware, or we are assisting people to be aware, even with criminality, it doesn't stop you from making an application, but understand the different process and how the application will be assessed by the caseworkers. And we've always said that not many people are going to read these big documents because it's like, they don't bother. But it's for the advocate and the person's thing will be able to do the background reading and able to guide and assist the individual, because they won't just bother to go through a document of that length.
It's essential reading, isn't it?
Yeah, yeah, yeah. But I think the most important thing is that as you said previously, Erman, if people are saying, well, I've got a criminal record, or I know, I'm not going to bother, we won't sort of advise them not to come forward. We're trying to explain to them, that they can still make application, or we need to explain to them how the application would be assessed.
So that brings up a good point. What if they do not disclose to us that they have a criminal conviction? They don't think it's important. It was 20 years ago. I didn't think that was important. It's 40 years ago. I didn't think that was important. I was a child. I was silly. I was young. I was, insensitive. Da, 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 da. And you make an application and it's refused. Then what? Instead of making it and it's refused, because you have to sign a declaration, I believe, stating that you believe this is this information is true to the best of your knowledge and belief, but you willfully, consciously left out information that could affect. They may consider that you were being dishonest or trying to mislead the Home Office, and that questions your integrity. That then puts into question your how truthful have you been about other things on your application.
Yes.
Especially if you're trying to go for the compensation.
Yeah.
That's a good point.
Could give rise to that.
It really happen.
I think that gives what you've just said there as well. And it's something I was trying to get through to some people previously with the Windrush, is your own personal case management when you sign on someone with you initially to agree with. We know you have a case, you're talking and you're trying to get people's confidence and so forth, but that's very clear that something has to be signed whereby, understandably, look, I'm helping you with this, but however, if there's anything that's found as such that you shouldn't have, you haven't told me about, and issues arise from there, you have to understand it is, and there's nothing wrong with that. Some people would like that, some won't like that, some will go, oh gosh, you're making things even more formalized or whatever. I'm afraid just for like efficiency and time and so forth, this the sort of thing I do at the triage entry. That's what you've got to do. Yeah. Or well before that application is sent in, that there could be particular junctures, particular areas in your helping and citing and helping, supporting someone. Yeah, but definitely before that goes off, yeah, that needs to be done. Yes. So and in the general, looking through things, it's very important what's been. But I think also what we have to do is augment the fact, make it loud. As it's been clearly stated in their guidance that it won't be reported to the authorities and so forth. And a lot of people have got, if they've got issues where they haven't got themselves after 30, 40 years, their status, there could be some issues. Some of them may well feel there's issues there, but we know the timeline. It's interesting. I don't know, did anyone partake in the visa information with regard to the Joint Council for Welfare of Immigrants recently?
I did
No?
circulate that information out, but I don't know.
Well, I did. It's very, very useful, especially the fee waiver. Fee waiver for the 20-year rule. But I know we'll talk about that another time. That was very useful, but that was free. But that's another thing that people could have in their arm, understanding. I think what Tanika's done today, it's very important to read. As many as people might want to help, I would have done this. I'm helping people, Windrush Advocate and so forth. These are some of the nitty-gritty areas you've got to really know. And obviously your client to be confident in you as well when you're dealing with them, in how which methods of approach, how you go about this. Yeah. So to me, it's been the time's been useful for me. As I said, I'm quite a boring person. I need to get a life. So but I know with cases I deal with, and this even enhances nice with regard to the waiver which was done. The next one is in September on the 20th. Tanika, you can do it. Roland, you can do it. I'm sure I've sent the information. It's free. It's like 6 o'clock in the evening to 8 p.m. Joint Council Welfare of Immigrants. And actually, when I get the information, all the slides,
I already do
I will
waiver
forward it to you. Sorry?
So
Sorry?
I am familiar with the fee waiver application process and what's not.
Great.
On a separate note. Not something I'm sorry to say that, but
yeah, and the 20-year rule and so on and so forth. So
yes,
it's interesting listening to some of the things you're saying here, because there are some issues with regard to how things are explained and so forth. So thank you for that. Today's been very good. It's been an eye opener. It's helped to put some more pieces in the jigsaw.
I'm not finished though. So in my summation, so I do interject because we only have 7 minutes left, and I do want to get the summary over from today's.
Wow, 2 hours gone already. Wow.
Yes. So in the second part of the summation is from the compensation side of things, criminality, and in conclusion, criminality under the compensation scheme only affects the impact on life section of the compensation under the heads of claims. It does not affect your ability or eligibility under housing, homelessness category, or any of the other categories, only impact on life. And it's down to the discretion of the Home Office, depending on the length of sentence that you would have served when it ended. And if it's 4 years or more specifically, then it'll need ministerial sign off. You could either get your full award, it could be half by 50%, or it could be declined according to what the guidance information that we went through today tells us. But it is still worth making it very clear. And if it is that you wanted to include it on the impact in life, well, you have to declare it in somewhere or another, then you have to provide mitigating information, such as you've changed what you've done or you've repented, and this is how you've taken measures to correct the harm or hurt you may have caused whenever, however long ago. But these are things people need to know. And they may just be rejected. Going back to the question, Garrick, you asked of what the Home Office refusal may state if it was to be declined in its entirety. I don't remember, and I don't know if I've ever seen one, so I can't really say one way or another. But if it was to be declined in its entirety, then do they tell the claimant why? Because of your previous conviction, your claim is denied? I think, something like that it says. because your previous conviction, or because of your previous conviction, we're going to only award you 50%, even though you may have sent in good corrector references to say that you've changed and what's not.
Yeah.
Even though that was one of the cases I had, and it's been many, many years, and the person has, tried to change their life and have evidence of it, it still wasn't good enough to really mitigate the degree. So again, it's down to the discretion. Like Herman, you said that word, discretionary.
Yeah.
It
Yeah.
is discretionary. And was a measure? Is it balance of probabilities? I'm not gonna go further with that thought.
Mhm.
But
Yeah.
nonetheless, the guidance
Yeah.
is there for the public to read. That's where we got the information from. It is in the public's domain. If you're unsure about something you read, if we can help, we will. If we can't, we'll say, well, we don't know, but we'll ask somebody who may know. More specifically, if your case involves immigration rules, because again, we know clearly, as today is proven, Windrush schemes are taken from immigration rules or created from immigration rules. It lends themselves directly. Some things have to be read in conjunction. They cannot be read or interpreted separately. So please do seek support from an advocate or somebody who may know a bit more than you. But as of the 27th of this month, if you need to contact us, also you can contact us at the Liverpool John Moore University Legal Advice Clinic in Hardman Street, Liverpool. It's a free clinic, Windrush Clinic. We'll be there also giving support with the Liverpool John Moore LAC team.
What day are you there? Days are you there in the month?
We're there 2 days. They'll be having clinics on 2 days, Mondays and Fridays.
What times are those from?
1 to 3 on Fridays, and I believe on Mondays it'll be the same timing, 1 to 3.
1
They
to
would be
3. And
published.
1 to 4,
are you
sorry,
there?
1 to 4. 1 to
Are
4.
you there? Are you there personally?
Yes, I will be there on Fridays personally.
Okay. Maybe this should be another time. If there's a case I'm working with, to seek some advice for you on that, is that something you'll welcome, or no, you've got to have the case lock, stock, and barrel to deal with it?
No, as I'm sure from the time you've known me, Herman, I'm happy to help, even if it's just to give advice on your case. You do not have to give me your case. Bring your case to me for me to have lock,
Okay.
stock, and barrel. No, if I can help,
Okay.
it's not about me,
Hmm.
our organization. It's about the individual we're trying to support. So whomever, wherever they get it from, especially if they're getting it from somebody who can give them the support they need, that's what's most important to me and our organization. And I speak for
Yeah.
Garrick on that when I say our.
Okay.
Yeah.
I've known some clients who've had some, decent settlements. But do you actually? One thing I was trying to find out, and I suppose it's how close you could get to clients, because obviously it's their right. Do you actually, when the compensation figure is given, the award is given, do they give a breakdown in the actual heads of claim areas, what they gave per area?
Yes.
Like if they say, oh God, you've got 80 grand, you think, but where did that? How comes I didn't? Did they give me impact at life? I don't know. Did I? It's
Yes,
just
they
a
do
lump
give
sum
you
of
a
money.
breakdown.
Do you actually get a breakdown? So
Yes,
you
they
can
do.
actually zero in on those particular areas where you think, hello, I think I should
Precisely.
have been awarded with them.
Yes.
Excellent. Great. Thank you for letting me know
However,
that.
in my
Because I was thinking
experience,
sometimes it might be some clients might think I'm being a bit nosy in a sense, venturing, as
that's
it
the
were,
point
to
I was
find
going
that
to
out.
make.
Do you see what I'm saying? So it's
Exactly.
their information. Okay. All right. I'll have
Unfortunately,
to.
that's what the problem is. A lot of them would see the money or see a figure and think, well, oh, yeah, that's amazing, but not really assess it. They just look at the whole figure. Whereas if they go back to the claimant, the advocate, sorry, and say, well, this is what they've offered me. I don't believe that they've considered where some other clients have done that. I
Yeah.
should have gotten a higher award or the higher bracket in this under this head of claim or that head of claim. Then we can review it and, well,
Yeah.
okay, in the
Yeah.
discussion of the breakdown, they'll say they've considered A, B, C. They were not eligible. However, X, Y, and Z, you were eligible. So this is what we've given you the award for. And if you do feel strongly
Yeah.
about A, B, and C, then we can go back to them with more evidence or arguing why you should have been given an award for A, B, and C in addition to the X, Y, and Z.
Yeah.
But unfortunately, claimants just see a figure and then that's it.
Yeah. Because once you do that, you've built up a pattern, a picture as such, haven't you? Because I know some applicants have told me they've known there's some clients that they definitely think we're in a good position to actually, definitely receive more. But what you've just said there, they've seen a figure and they've said, okay, that's enough for me. Yeah. When they may have tens of thousands of pounds have actually just basically written off, as it were, waved away.
That's
But
thing,
thanks for that.
That's the thing. Often the claimant doesn't even share that information with the advocate. They get the check, whatever it is, and that's it. You don't even know. They don't even say, thank you very much. I received this. Some may do that, but they just don't.
See, that's the compensation scheme. We're bogged down in the quagmire with, rightly or wrongly, the immigration information. And even what we're talking here, and with regard to the blood plasma group and the post office group, it seems to me there's a threshold they've got, and they just get a block sum of money. That's it. Yes, there isn't any sort of there's no gerrymandering, so to speak, or sort of navel gazing, or with discretion thinking, what should we give them here? With that. But anyway, I should stop moaning. We know it's going to be a long, hard fight.
Lastly, we are a minute after 5, so we're just over our time. But lastly, what I want to remind the listeners too is as of the 31st of December 2024, there's going to be a changing from the BRP cards into e-visas, and you have to register online. So from next year, if you're coming through the Windrush schemes, you would not be getting the BRP cards anymore. You'll be getting the e-visa. So if you need help registering for the e-visa, if you already have a BRP card, and reach out to us also, we can help you with that. It's not particularly
thank you for that.
Even though it should be. And I've done it a few times, and each time it's made me pause and think, to say the least. So please, if you need help with that also, reach out to us. They've estimated that over 200,000 people are going to be affected, and it'll be another Windrush scandal. Do not wait until the 31st of December to try to convert it over or to register. It's not worth it.
I appreciate that. But you know what you've just said there?
December is only 3 months away. So, it's time. It's only 3 months away.
I know what you've just said there, but even talking about Windrush, it means like there needs to be a call on that in the community, just on the e-visa. Yeah? Forget about all the compensation scheme and all that. Just those who've got the e-visa.
That would be priority.
That's needed. That shout's needed now, with projects being run and so forth. So just some ideas, but it'd be good to actually try to work with yourselves with that, in conjunction with that, because you've got some skills resources there that down here in London. I know this with regard to with Roland as well. So with Garrick and yourself and Roland, they're the ones I would work with. Thank you very much for today. I can't think of anything else. I might give you a ring. When are yourselves going to okay, with regard to today?
We're still recording, so thank you. I'll close off first, Herman, on the recording before you continue with your question, which I think I know what it is. So thank you all for listening today. I hope today was useful and helpful. If you need help, like we said at the beginning, reach us at our website or through our website, www.liverpooladvocateswindrush.org, or email info@liverpooladvocateswindrush.org. Thank you very much and have a blessed month. See you guys at the first Sunday in October. Garrick?
Yeah, that's all great. Thank you.
And in the meantime,
the recording now.
Yes, stop it. Please.
In the meantime, if someone thinks of a question within the next month,